Professor Salmond, the English jurist and legal philosopher, defined positive law as the first or basic or essential principles of a natural legal system. So he identified it with municipal jurisprudence or the civil law of that land or of that state or of that country. So he delinked law from political sovereignty as defined by John Austin. He entirely linked law with law courts and in the administration of justice. So his main focus was on justice, and justice, how it could be achieved through courts of law. So whatever the courts declared or decides in the administration of justice, that is positive law. So he does not include that positive law which was defined and explained by John Austin. So also he rejected international law as it is not a kind of positive law, as there is no systematic knowledge of any legal system. In this way, by defining and explaining positive law, Salmond divided it into two senses. One is the generic sense, and that generic sense is an wider sense of defining positive law, and in which he includes the entire body of legal doctrines and legal principles which are universal and common or similar to every legal system. And in this second division, that is regarding defining it in specific sense or a narrower sense, Salmond expressed that law of any portion of the doctrines, or it is the science of the first principles or the fundamental principles of civil law, or the basis of legal system of any country, that is the positive law as expressed and defined by Salmond. But he was strongly criticized for rejecting international law as a positive law, as because now we found that behind international law there are certain implementing and enforcing authorities such as the United Nations, the General Assembly, the Security Council, the International Court of Justice, and the International Criminal Court. So nowadays international law is gradually taking the shape of a positive law. Besides that, his exclusive importance and emphasis on courts of law and on administration of justice, he left the very sovereign body, that is the parliament, who makes law. So that's why he was criticized on giving all importance to the aspect of justice and about the courts of law. So also his definition is considered as a narrow definition of positive law, as because his definition of positive law in specific sense is limited and narrow in their application, as positive law is a kind of law which is common to every country and to every legal system, as behind there is a political sovereign authority, either the head of the state or the head of the government or a parliament which makes law and which implements and executes law. So solely he relied on the courts of law and on the very idea of justice. For that, his definition of positive law is considered as a narrow definition of positive law.